Welcome everyone to this really important webinar on the International Court of Justice case and the provisional measures that have just been announced a few weeks ago by the ICJ. I have the privilege of being joined by a number of eminent speakers who will be sharing their reflections and thoughts with you. But before doing so, I really want to warmly welcome Professor Mary Bassett, who will be offering a formal opening and some introductory remarks. Dr. Bassett is the director of Harvard University's FXB Center for Health and Human Rights and serves in various capacities within Harvard and outside of Harvard. I'm going to hand over to Mary to welcome you all and to make some opening remarks. Mary, over to you.
Thanks very much, Kayum. And I want to welcome everybody as people are trickling in and joining this important discussion, which I'm very pleased and honored that FXB is hosting. Focuses on the case that was brought before the World Court by South Africa against Israel on a charge of violating the Genocide Convention, to which both nations are signatory. Just as context, as of this week, Israel has killed over 27,000 people in Gaza, over 11,500 of whom are children. Many more people have been injured and thousands are missing in a military action that began following the October 7th Hamas attacks, in which some 1,200 Israelis died. The impact on Gaza's infrastructure has been immense. About half of homes in Gaza have been destroyed or damaged. There are no remaining universities in Gaza, and there are growing concerns being voiced by UN agencies that the territory is on the brink of famine. So on January 11th, the South African legal team argued at the top UN court, the International Court of Justice, that Israel, in action and intent, breached the 1948 Genocide Convention by perpetrating the following acts of genocide in Gaza: mass killing of Palestinians, bodily and mental harms, forced displacement, food blockade, and destruction of the healthcare system, and preventing Palestinian births. On January 26, the court ruled that the South African claim was plausible and would be adjudicated. As an interim measure, it ordered Israel to take all measures to prevent civilian deaths, destruction, and prevent and punish the direct and public incitement to genocide in Gaza. And they also ordered Israel to report back to the ICJ in 30 days. South Africa had requested a ceasefire order, which was not ordered by the court. So this is what we're going to be hearing discussed. I think someone will put in a link somewhere, a link to the arguments before the courts and the court's judgment decision, which are all available on UN TV and you can watch for yourselves. Before turning it back over to Kayum Ahmed, I'd like to give a couple of thanks to those who are co-sponsoring this webinar with us. They are the Harvard Center for Middle Eastern Studies, Religion, Conflict, and Peace Initiative at the Harvard Divinity School, and the Carr Center for Human Rights at the Harvard Kennedy School. Back to you, Kayum.
Excellent. Thank you, Mary, for those really thoughtful and insightful comments that I think provides us with a really good overview of where we are at the moment, and is the perfect setup for our first speaker, Rania Mohareb, who is an Irish Research Council and Hardiman PhD scholar at the Irish Centre for Human Rights at the National University of Ireland in Galway. Her PhD research examines the relevance of the apartheid framework to the Palestinian struggle for decolonization. Rania will have 15 minutes to speak, following which we will hear from Dr. Tlaleng Mofokeng, the UN Special Rapporteur on the Right to Health, who I will introduce after Rania has concluded her remarks. Rania, over to you.
Thank you so much, Kayum. Thanks for organizing the webinar and for the invitation to speak. So I will be focusing on framing Israel's attacks on healthcare in the context of Israeli apartheid and settler colonialism. But before I do so, just by word of introduction, I want to highlight that in this case before the International Court of Justice, South Africa recognized the importance of placing the acts of genocide in the broader context of Israel's 75-year-long apartheid, 56-year-long occupation, and 16-year blockade of Gaza, including serious and ongoing violations of international law, war crimes, and crimes against humanity. And on the 26th of January, the International Court of Justice ordered provisional measures in this case, which inevitably require a ceasefire to be implemented, as many have observed. At the same time, South Africa's application also recognized that, above all else, Israel's military assault on Gaza has been an attack on the medical healthcare system, indispensable to the life and survival of Palestinians. And for months now, we have known the facts documented so meticulously in South Africa's application that the Israeli occupying forces have targeted hospitals, ambulances, medical convoys, first responders. They've besieged hospitals and continue to do so, targeted generators, solar panels, and life-saving equipment, and killed some of the most experienced and skilled healthcare workers in the Gaza Strip, together with members of their families. So we have a responsibility to stop this genocide, to achieve a ceasefire as recommended by many and as required for the implementation of the provisional measures by the court. What I'll do in my presentation is I'll start by contextualizing some of these attacks on the healthcare system and then discuss the impacts of Israeli apartheid on health before concluding regarding the need to address the root causes. So first, it's important to note that Israel's deliberate and systematic attacks on Palestinian healthcare are by no means new, and these have been ongoing for decades. South Africa makes clear, for example, that Israel's targeted attacks must be understood as an attack on the future of the healthcare system, destroying its capacity to rebuild and to care effectively for Palestinians. The World Health Organization has a database recording attacks on healthcare and recorded more than 800 attacks on healthcare in Palestine in 2023, which make up around 58% of global attacks on healthcare last year. And just since the beginning of this year, WHO has recorded 20 attacks on medical facilities in the occupied Palestinian territory, 36 attacks on transports, 61 attacks on healthcare workers, 45 attacks on patients. And these cases include also arbitrary detention of healthcare workers by the occupying forces, violent searches of healthcare personnel and facilities, threats of violence and intimidation, and obstruction of healthcare delivery. WHO has recorded hundreds of such attacks in the last 4 months, not only in the Gaza Strip, but also in the West Bank. Just last week, on the 30th of January, Israeli special forces disguised as civilians, nurses, and doctors stormed the Ibn Sina hospital in Jenin and extrajudicially executed 3 Palestinians at point-blank range, including a wounded patient who was undergoing treatment. So this was documented by Palestinian human rights organizations, Al-Haq, Al-Mizan, and the Palestinian Center for Human Rights, who also warned that Israel is turning hospitals into another crime scene for extrajudicial killings in the West Bank. It's therefore important to underscore that Israel's attacks on healthcare aren't isolated, but are systematic in nature. In 2019, for example, the UN Commission of Inquiry on the Great March of Return demonstrations in the Gaza Strip, which demanded the lifting of the illegal siege and blockade, it found reasonable grounds to believe that Israeli snipers shot at journalists, healthcare workers, children, and persons with disabilities, knowing they were clearly recognizable as such. Yet there has been no accountability for these massive attacks on the healthcare system. All of this, of course, is happening within a broader context. For 75 years, the Palestinian people have been deprived of the exercise of our inalienable rights. Millions of Palestinian refugees continue to be denied their right of return, including in Gaza, and to be denied the right to return to their homes, lands, and properties since 1948, the beginning of the Nakba. The catastrophe. South Africa has importantly recognized that this Nakba is an ongoing process of continued colonization of Palestinian land on both sides of the Green Line. When it comes to fulfillment of the right to health, under international human rights law, the fulfillment of the right to health requires the realization of underlying determinants of health and well-being, which are closely linked to the enjoyment of all other rights and freedoms, including political rights, self-determination, but also the rights to adequate water, food, housing, and education, all of which have been under attack in Gaza and in other parts of Palestine. So with that, I want to talk a little bit about apartheid and its impact on the right to health. So the term health apartheid refers to a series of racialized Israeli laws, policies, and practices that dominate the Palestinian people and deny Palestinians the fulfillment of their right to health, including denying freedom of movement and access, fragmentation of the Palestinian territory, the development of the healthcare system, as well as the attacks on healthcare, the killing of healthcare workers, and the destruction of health infrastructure. It's important to understand the denial of the right to health as encompassing not only the right to receive, not only the denial of the right to receive adequate medical care, but also a broader system whereby the oppression and domination of Palestinians precludes the fulfillment and exercise by Palestinians of fundamental rights and freedoms. So in 2019, for example, the UN Committee on the Elimination of Racial Discrimination found that due to racial discrimination, Palestinians suffer shorter life expectancy and higher rates of infant mortality. This is just one example of the structural impacts and implications of Israel's apartheid on the health system. Apartheid constitutes a crime against humanity under international law. It is prohibited under the 1973 Apartheid Convention and the 1998 Rome Statute of the International Criminal Court, and gives rise to individual criminal responsibility. Deliberately inflicting conditions of life calculated to bring about a group's physical destruction in whole or in part is part of the definition of the crime of genocide, as South Africa shows in its application, but it is also recognized as an inhuman act of apartheid under the 1973 Convention, when it's committed for the purpose of establishing and maintaining domination by one racial group over another and systematically oppressing them. During the period of apartheid in South Africa, the UN held a series of conferences and seminars on the impact of apartheid on health. These highlighted that systematic denial of fundamental rights, dispossession from land, and the inferior legal status imposed on Black South Africans all work to undermine their physical and mental health. There, the World Health Organization advanced a root cause analysis and recognized that apartheid is inimical to the right to health, has undermined every aspect of life from cradle to grave, is a source of psychological stress, of economic deprivation, poverty, and basic insecurity. In 1981, the Brazzaville Declaration, adopted at the International Conference on Apartheid and Health hosted by WHO, was clear in its findings that, and I quote, "It's impossible to speak of health in the absence of political rights, self-determination, and acceptance of the principles of social justice as imperative for society as a whole." And WHO concluded at the time that change required the radical dismantling of the apartheid system and of racial discrimination to enable the realization of the right to health. The same root cause intervention is now required in Palestine. Israeli apartheid and Zionist settler colonialism, which have long been recognized, including in recent years, must be dismantled. And this is not a new analysis, but one that is consistent with the UN and WHO's work on apartheid and health in previous decades. I want to note here as well that this is discussed in a lot more detail in a piece published with Ben Bouquet and Rona Smith in the Health and Human Rights Journal in December 2022. I will conclude by saying that the realization of the right to health of Palestinians is intrinsically linked to ending Israel's system of racial oppression and domination, and by addressing the root causes. We must therefore advocate for the realization of the Palestinian people's right to self-determination, an end to the ongoing Nakba and occupation, the lifting of the blockade of Gaza, and realizing the right of return of Palestinian refugees. And these are rooted in Israel's settler colonialism and apartheid over the Palestinian people, which has long been recognized, as I also mentioned, by scholars, grassroots movements, civil society, as well as the UN, bodies, experts, and states. And I'll conclude by saying that in November 2022, in a report for Al-Haq, together with co-authors, we detailed Israeli apartheid as a tool of settler colonization, and we detailed these policies of health apartheid, which are premised on the elimination of the Palestinian people. In that report, we said that we remain convinced that without the complete and radical dismantling of Israeli apartheid and settler colonialism, dignity, justice, liberation, and self-determination have no future in Palestine or elsewhere on earth. And I think these words ring particularly true today. So our push today should be for a permanent ceasefire in Gaza in fulfillment of the ICJ's provisional measures order, and on addressing these root causes, advocating for freedom, justice, and equality for the Palestinian people. Thank you.
Rania, thank you for that excellent overview of not only the law, but I think the interpretation of how the laws are applied in these different contexts. And you spoke about apartheid, settler colonialism, acts of genocide, and the Nakba, of course, which I think is an interesting concept that's increasingly being used as a framework developed by Palestinians to make sense of what's currently unfolding, rather than talking about the Nakba as an event that happened 75 years ago, a sort of ongoing, continuing framework that's used to characterize and shape the conversation. So thank you for connecting the dots between all of those different components of the legal framework. And so building on that, I want to hand over to Dr. Tlaleng Mofokeng, a fellow South African and UN Special Rapporteur on the right of everyone to the enjoyment of the highest attainable standard of physical and mental health. Dr. Mofokeng is a medical doctor with expertise advocating for universal health access, HIV care, youth-friendly services, and family planning. Dr. Mofokeng is a member of the boards of Safe Abortion Action Fund, Global Advisory Board for Sexual Health and Wellbeing, Accountability International, and she's also the chair of the Soul City Institute board, among many, many other hats that she wears. Dr. Mofokeng has also made several public comments about what's currently unfolding in Gaza. And if you don't already follow her on Twitter, you absolutely must. She is an important voice in the social media space as well, in terms of carefully connecting the dots between what's unfolding and the right to health. So I'd like to hand over to you, Dr. Tlaleng Mofokeng, to share some of your thoughts and reflections on your mandate and how that has been shaped by the current crisis. Thank you.
Thank you so much for that introduction and for inviting me to share with you this space today. And I think Rania's introduction is really great because a lot of what many of us are experiencing and witnessing right now, for many people sounds like history, but for many of us, it's the present, and it's a history that is very academic for some people, but for many of us, it's quite visceral. And just to say that I myself grew up in apartheid South Africa, and as an 8-year-old, my core memories of childhood were around throwing stones at armored vehicles in a Bantustan segregated area where I used to grow up in Gwagwa. So a lot of what is happening, what we are witnessing with children in Gaza, for me has been a reliving of some of the most incredibly excruciating trauma. And so this work comes from that place that is full of rage and full of fury. And I just wanted to acknowledge that before I make my interventions. I think we know that, working within the multilateral system, one isn't a diplomat, you're not, employed by the UN, but you are independent and as an expert. And I take that role very seriously in terms of what the mandate is of the right to health. And in 2022 and 2021, I actually presented a report on violence and its implications on the right to health, and also did a report on racism and its implications on the right to health. I also started my mandate giving a statement at the General Assembly in terms of my overall vision for this mandate. And I had said at the time, it was important to center dignity of people, but actually the restoration of dignity of people. Because I recognize that for so many people that look like me, that sound like me, that have a history of imperialism and apartheid and colonialism, that in fact, where we are in our lives, we only got here because of series of miracles. But what it will take for the world and for the children and for everyone, everywhere to thrive is more than just a series of perfectly aligned miracles, is that human rights are the only solution forward, and that human rights are actually solution orientated. And it was because of that personal experience that for me, and the mandate on the right to health for my tenure revolves around the idea of restoration of dignity. And to do that, there was an honesty that I felt was missing in the global health space, in the world generally, about racism and coloniality, and the fact that it was always spoken of as if it's in the past. And what has happened right now since the 7th of October in terms of the acute escalation on a very chronic problem is a very reminder of why the anti-racism and the anti-coloniality frameworks I use to analyze and to do the work as a mandate holder at the UN is very important. Very early on, people didn't quite understand why that was important, and why even in my approach to particular recommendations that I make and particular interventions that I make, I always center the idea that we need to think about the people at the margins and think about the multiple locations that people find themselves on, but also think about the crushing weight of discrimination and racism and structural causes of particular health outcomes, and locate those not within the individual and not locate vulnerability within an individual, but locate those within particular systems that fail. And we know that violence is a major obstacle to the enjoyment of the highest attainable standard of physical and mental health. And this is important because violence, whatever context it's happening in, does amount to violations of a number of other human rights: the right to life, right to health, freedom from discrimination, equal protection under the law, freedom from torture and from cruel or inhumane or degrading treatment, and also the right to justice and recourse when things do go wrong. And we can see already, before you even analyze any genocidal conventions, you already see why there is a problem right now with the aggression of Israel onto Gaza. And already in October, I released a statement, of course, calling on the international community leaders that an immediate ceasefire was the only way forward. And I remember even at the time, everyone was concerned about humanitarian aid and humanitarian corridors. But my argument has always been that Gaza has always been a humanitarian disaster before October the 7th. So appealing to more humanitarianism in the context of that historical, ongoing, escalating aggression, which is funded by allies of Israel, some of the biggest nuclear powers in the world. It cannot be that the sum total of what the world leaders are demanding is a humanitarian pause. And that for me was quite disappointing and frankly, very sad to realize that we actually do not have the leaders that we need, that we deserve. And for this moment, that they are failing us. Unfortunately, within the multilateral system, they cannot hold themselves and each other accountable as peers, as member states. And so what areas and what possibilities of recourse from a restoration of dignity perspective, for a protection, a fulfillment, and a respect of a right to health perspective, what is there that then rights holders in Gaza, in the occupied Palestinian territory have? And I think that's why, therefore, then the case that South Africa brought in the International Court of Justice was quite important, because we observed multiple times Security Council meetings where decisions around a ceasefire were vetoed. We saw and noticed how sessions were postponed while member states were negotiating on language, and how even the possibility of a ceasefire was completely erased from the text. We've seen how in the General Assembly, member states stood up time and time after session to reiterate one issue, is that there has to be an immediate cessation of hostilities, and yet all of that has failed. And so I, in the context of the role at the UN, part of what I do is respond, of course, to allegations of human rights violations. And some of the communications that happen within the UN are confidential for a period of time. And so in a letter that is, I wrote to the government of Israel on 4th of December 2023 already, I was highlighting to them at that point that, in fact, I have received concerning allegations related to violations of international human rights law, and that the ongoing conflict in Gaza, of course, had a particular attack on hospitals and healthcare facilities and healthcare workers themselves, that the escalation saw for the in an acute moment, quite what I called an attack on the practice of medicine, where people who are oath takers, the nurses and the doctors and the paramedics, who did not leave and did not neglect their patients, they themselves were targeted, and they were working and killed, and they were working under bombardment. And at the time of this letter of 4th of December, there were already so many allegations that I had received. And at that time, it was 14,854 people who had been killed in the Palestinian territory at that time. And we had already received specific allegations concerning specific healthcare facilities all the way from the 7th October. But at the time, we were quite concerned about medical supplies and equipment running out. We were worried at the time about fuel and electricity and water cuts. And of course, the Al-Shifa and Al-Indonesi hospitals, had been working on secondary generators for a few days before, well, at least hours before they stopped working because of a lack of fuel. And I think the timing is important to illustrate how passive and how slow the world has been to respond to the issues of utmost emergency. And I will say this because I know from previous, briefings, from previous academic work, that Palestinian people are not exceptional. They are not even asking for exceptionalism. But there is something to be said about the type of imperialism, the kind of sponsored violence that happens in Gaza, in the occupied Palestinian territory. That I was often worried, and I did say this, that the humanitarian pauses and those evacuation orders were in fact making way for more land encroachment and more displacement. And they were actually not well thought out in terms of an overall agenda that is going to affirm the right of Palestinians to their own land and to self-determine. And those evacuation warnings and the demands that people evacuate their homes and hospitals were in fact themselves a form of repeated trauma and violence to the Palestinian people. And that the multilateral system, the global community, needed to interrogate a bit more deeply and honestly what it meant to ask people who were already living in an open air prison to then further evacuate in that little space where, whether you go north, west, or south, or east, there literally is nowhere to go. And how inhumane that was, to then call for a humanitarian pause where you can get supplies, get food and electricity, and continue bombing people as if that band-aid of a full stomach for 24 hours is enough. I mean, what was the world really saying? Let's feed you for 24 hours and continue to bomb you again. It's almost like people are not hearing themselves. And for me, what worries me is that these are the best of who we look up to as leaders. These are the best minds that we say we are calling on to when we talk about international community, when you're talking about protection of human rights and prevention of violence, because we're not part of the big role of these systems and these organizations is to prevent violence. And so in the context of ongoing acute violence, that historical, but also in the moment, you have such horrific live reporting of the violence. And all we could come up with for literally 2 months was that we want a humanitarian pause in Gaza. That was simply not acceptable, and it's simply still not acceptable. So I come to you today with not much hope or positivity, but a sense of absolute disappointment and absolute disgust at what is currently happening and how all of us, including people in Gaza, especially the people of the occupied Palestinian territory, have been let down. And so with the allegation letter that I wrote to the government of Israel, it displays a litany of particular situations, including in the West Bank, where we were told that the West Bank is not under attack. The attacks are very localized to specific areas where Hamas is. And yet, even as early as 4th of December, when I wrote that letter, there were already documented attacks even in the West Bank. And up to date, there has been no response to me, in my capacity as the special rapporteur to that letter from the government of Israel. And what was important then is that I did mention to them, of course, and reminded them that every human, every person has a right to life and security and not to arbitrary deprivation of life, the right to enjoyment of the right to health and inter alia, and of course drew on international human rights law, but also drew on international humanitarian law as well, and reminded them of their obligations because they did ratify the Convention on the Covenant on Civil and Political Rights in 1991, and as well as the International Covenant on Economic, Social, and Cultural Rights. And all of those contain very specific articles and comments on the right to health and their obligations. And as occupying power, even during COVID, I did write to government of Israel, reminding them as well at that time of their obligation as an occupying power in terms of the right to health and what must be done in terms of the provision of health and non-discrimination of the people in the occupied Palestinian territory. And I just want to close in saying that the occupation currently happening in the occupied Palestinian territory is already violence. Not the response to the occupation is the violence. The very occupation itself is provocative and is violence. And that the very imperialism that we see and the arrogance that we are currently seeing displayed for all of us by the allies of Israel is the most despicable possibly in our lifetime. And that to get to the root cause of all of this and to get to peace, there has to be an end to the occupation. There has to be justice for people of the occupied Palestinian territory. There has to be self-determination. They have to take their land back. And there must be liberation in order for there to be peace. There is no future where there is war for me. The future that I'm trying to create has no place for war. But in this current context of the moment where we live, we have to really demand that the world leaders, that the occupying power understands their obligations, of course, in terms of the Geneva Convention, international law, and all other conventions, right, respecting of laws and customs on land throughout of the occupied Palestinian territory, and that the applicability of international human rights law in this context of conflict and or occupation with international humanitarian law has been widely affirmed. And contrary to what the government of Israel is trying to do, we know that conflict does not release a state from its human rights obligation, period. And there can never be an excuse for a genocide. It does not exist anywhere. You cannot excuse a genocide. And I think that's what's really important. And hopefully in the future, there will be an update. There will be an engagement with this letter that I have sent them. But in the interim, we remain hopeful. We remain absolutely irrational in our quest for justice. We remain unreasonable in the quest for restoration of dignity of the people of Palestine and for the people of the world everywhere who continue to live under the crushing weight of imperialism, of racism, of structural discrimination and land dispossession, because this is a pain that we know very well. It's not an academic exercise for many of us. And it's with that spirit that I do this work in, and that I hope that we can, in future, be able to do and see a free Palestine, in our lifetime, the same way that we saw a free South Africa in our lifetimes. Thank you very much.
Thank you so much for those incredibly powerful and inspirational words, Dr. Mofokeng. You have been a voice of reason, I think, in the midst of global silence in many ways on what's unfolding in Palestine. So we completely appreciate your comments. I also wanted to just acknowledge your personal reflections at the start of your comments about being South African, having experienced apartheid. And so drawing those comparisons between South Africa and what I've referred to myself as the metastasization of apartheid by the Israeli government. And then, of course, we noted your critiques of the multilateral system, which you indicated requires some interrogation. And I think that includes and incorporates the humanitarian pause, which clearly is completely inadequate, but also, as you say, the contravention of international human rights law. And so to help us think through the legal dimensions of those contraventions and what they might hold for us in the context of this ongoing case, I want to turn to our colleagues from the International Commission of Jurists. We are joined by Timothy Fish Hodgson, who is a legal advisor at the International Commission of Jurists, as well as Catherine Iliopoulos, who's also a legal advisor for Libya and Palestine. And our colleagues are going to help us think through some of these very important questions that were raised by both Rania and Dr. Mofokeng, on how to connect the dots between the legal framework, the international legal framework, as well as some of the critiques of these frameworks in the context of what's currently unfolding. So I'll hand over to Tim and Catherine. We may be experiencing some technical difficulties. Let me just try and understand what's happening. So it appears that we may have lost.
Yeah, I believe that Tim was going to go first, and then I was going to speak after Tim. But I cannot.
Hi.
There.
Oh, hold on, Tim. You're a little. There's a bit of a delay. Could you just say hello again? I think it might be better now.
Hello.
Maybe Tim, if you could try turning off your video, perhaps it's a bandwidth issue.
Yeah, my internet has, with my power, gone down, and so I've had to join with my phone. Apologies.
No worries at all. We completely understand. We can hear you clearly, so please go ahead.
Okay, thank you very much, and apologies for that. This is some of the problems that South Africa is facing ourselves, including power problems and things like that. Kayum, please just nod if I'm not audible. But it's difficult to actually add, and I will try and add. And I always say at the beginning of presentations on this topic at this present moment that it's actually very difficult to say anything that sounds meaningful about human rights in the context of their wide-scale abuse on the level that it is. But I think that what my colleague and I will talk about today, we will try and talk in and around a little bit more the International Court of Justice decision and say some things which hopefully will add to a conversation which is obviously ongoing publicly and continuously now. And the first thing that I want to say before I get into the meat of it is that one of the things that is just obvious as a lawyer but might not be obvious outside of that is that for a court to restate the law and put it to a country or any party in any place and say that there's a plausible case of a violation of the law, it may seem like nothing because it's just like the court could be saying, well, don't commit a crime which everybody knows is a crime. But that isn't nothing because it's quite a high level to get a court and to persuade a court, especially on such a very politically controversial issue, to so unanimously say that genocide might be happening, that it's plausible, that it could be happening. And I think that that's often missed in the analysis of the importance of the International Court of Justice decision. Now, to add to what we've already spoken about today, the order of the court says two things that I want to hone in on, which I think have some relevance to the right to health. The first is it talks about telling Israel to desist from deliberately inflicting on a group of people conditions of life calculated to bring about its physical destruction in whole or in part. The second one is related to humanitarian aid. It says the state of Israel shall take immediate and effective measures to enable the provision of urgently needed basic services and humanitarian assistance to address the adverse conditions faced by Palestinians in the Gaza Strip. Both of these speak to the living conditions of persons in the environment. Now, what I would say is that the minimum level the minimum level that these phrases can be interpreted with is in light of international human rights obligations that Israel has, including obligations in terms of the right to health. It's interesting also to talk about, and I think it's that when when the previous speaker spoke about apartheid, it was already pointed out that this phrase on the deliberate inflicting on a group of people conditions of life calculated to bring about destruction, it's used in the Apartheid Convention, although the Rome Statute then defines apartheid more broadly. So you don't even need quite to get up to that level. But the inflicting on a group of conditions of life, on suffering based on an intention to destroy that group or an intention to separate, segregate, and undermine that group is recognized in multiple platforms as a crime against humanity in international law. And it's quite important that it is. Why people like me who are experts in economic and social rights don't often end up talking on platforms about cases like this is because we are not necessarily experts in international crimes such as apartheid and genocide. But there is a very important reason to talk about them on platforms like this, because they are related to economic and social rights, and because they are very much related to health. Because as we see over a period of time, and as Dr. T already spoke about, there's much more going on here than the case itself specifically. So if we talk about the relationship between the violations of the right to health and apartheid and genocide, other than pointing out the similarity in the definitions and pointing out, as I already have, that economic and social rights must be a way to determine it, what we have to say is that in terms of the right to health, the right to health must be available, accessible, affordable, and of sufficient quality. Now, this might sound banal in the context of the bombing of hospitals or the destruction of infrastructure that allows access to medical care. But the point is to make that actually what we see daily on TV and what we know is happening and what Palestinians are experiencing is something that goes much, much further than failure to provide or ensure availability, accessibility, affordability, and quality healthcare services. And as Dr. T points out, as the occupying power, this is what is required. Now, at some point, failing to provide what is required exceeds a violation of the right to health. And the violation of the right to health becomes a component of illustrating apartheid or genocide or any of these other actions and should be able to be taken account in that context. I made the point on a previous webinar with similar colleagues that there are many ways in which Israel is clearly violating the right to health and has been doing so over a period of time. The first is failing to take positive steps to provide access to health as an occupying power. The second is by destroying or inhibiting access to healthcare, by destroying infrastructure, by chasing away workers, by killing people. And that is a violation of the duty to respect the right to health, as is preventing access to aid in the form of blockades or anything else, electricity cuts that prevent access to healthcare or any other such action. And then the fourth, which is not often enough spoken about, is just by not regulating or stopping third parties, including Israeli settlers, from doing things, from creating an environment which harms the right to health. And you could say this about various other rights, adequate standard of living, housing. We're just focusing on health here because of the context. Now, when it comes to the ICJ ultimate decision, one would hope that they might be taking into account things like this. And one of the reasons why they might not, and why I want to emphasize things that go outside of the International Court of Justice decision, is because it was deliberately aimed at producing a ceasefire and ending the hostilities for the time being, at the very least, to ensure that Israel can be held accountable, is that it really dates from the 7th of October. And this context that's provided as context is not part of it. So the first point that I want to make is that the case that is being argued against Israel in this case is about whether or not there's a plausible genocide dating back to the 7th of October. Now, if you apply the definition of genocide and Article 2C, which has got to do with the conditions of life, to a longer time period, it's quite easy to see that actually the range and number of cases and the range and number of violations that provide evidence for it, and the range and number of sources that provide evidence of intention to potentially destroy a people, and to potentially displace a people, and to potentially segregate a people become much stronger. And so the answer to this question, and the fact that the court has been able to say that there's a plausible case of genocide, even just from 7th of October, should be understood in the backdrop of the context that what if the allegation was made in a broader lens and for a longer period of time? The second thing to emphasize is that the direction by the court that Israel should take steps to prevent genocide and to take steps to not commit acts of genocide does not mean that other international human rights law and international humanitarian law standards cease to exist or cease to apply. And any finding of the court, even if the court were to find that since 7th October there hasn't been a genocide, that would not mean that it's finding any lack of other violations of obligations that Israel has, or failure to fulfill its obligations that Israel has done, including in relation to apartheid and genocide in the broader frame. I want to just talk about other accountability measures quickly before I end. And of course, there's lots of domestic court cases that we could talk about and domestic advocacy. But I just want to bring attention to one thing which is not getting spoken about that much. And that's the request by the UN General Assembly for an advisory opinion from the International Court of Justice. Now, the International Court of Justice has separately been asked to give a much broader advisory opinion on the legality of the occupation itself and the implications and consequences thereof. The proceedings for this actually start on the 19th of February in a little under 2 weeks. And this follows the General Assembly resolution on the suggestion of the Independent International Commission of Inquiry on the occupied Palestinian territory, including in East Jerusalem and Israel. Now, the Commission in its report, when making recommendations, notes the following. Israeli policies outlined in the present report, such as those on expropriation of natural resources, on building restrictions, have directly affected economic, social, and cultural rights of Palestinians, including their rights to housing and adequate standard of living, food, water and sanitation, healthcare, and education. Now, all I'm wanting to say is that this is a much broader mandate for the International Court of Justice to much more expansively look at the conduct of Israel over a very long period of time and over a wide category of issues, not all of which have to be explained in terms of international crimes that have very high standards of proof. And what is likely to come out of this International Court of Justice advisory opinion, or what I would hope is likely to come out of it, is a much bigger, broader frame, which has been illustrated in the conversations that we have, that illustrate that actually what we need is not only a ceasefire from the current hostilities, but a complete end to the regime of oppression and the regime of harm of human rights that has been conducted for decades and decades at the expense of the Palestinian people, in complete contravention of the right to health and all other human rights. I hope that this gives a little bit of a background and context, and I think Catherine will now speak much more because she has the expertise on genocide in particular.
Tim, thank you so much. That was incredibly helpful, and I appreciated the intersections that you drew between economic and social rights more generally and the Genocide Convention, and how these different pieces of international human rights and humanitarian law coalesce in this particular case. And then also thank you for highlighting the hearing taking place on February 19th. I think in the context of what's unfolding with this particular ICJ case, we shouldn't forget about all of the other cases that are pending or potentially unfolding. And there have been cases in the United States and further cases that are being planned to take on some of the allies of Israel who are supporting supporting them by providing them with weapons and other financial support. So important to draw those connections. So I'm going to hand over to Catherine, who's going to take us through the next phase of the presentation. Over to you, Catherine.
Thanks so much, and thank you to Tim and to the previous speakers as well. And I'm going to aim to try to draw on what the previous speakers have said and what they've shared, and try and frame it within the context of the case that South Africa has put forward. So just to quickly recap, of course, to order provisional measures, the International Court of Justice did not have to find that genocidal acts had actually occurred, but only that the claim for the protection of rights under the Genocide Convention was plausible, and it did make such a finding. So in doing that, it considered that there is a real risk that there is a genocide occurring or will occur. Of course, a determination of whether Israel's conduct amounts to genocide is for the merits phase of the proceedings, which, going by previous cases, it will probably occur years from now after other stages have been completed. For example, Israel will have the opportunity to challenge the jurisdiction of the court on the merits, as opposed to, of course, the jurisdiction on the court has found it had jurisdiction to order provisional measures, but it also has to deal with the question of jurisdiction on the merits, and this will happen. And then parties, both sides, will file additional briefs, and other states can intervene and they can submit written pleadings as well, where they outline their positions on the facts and the law. So all of these steps will take place before the court actually rules on the question of whether the Genocide Convention has been violated by Israel. And as has already been mentioned, the court ordered 6 measures, and I will focus on the measure that was imposed in relation to the provision of humanitarian assistance, because this relates most closely to what we're speaking about today, which is, of course, the right to health. Now, another, just to add for information, of course, we have the crime of genocide being defined in the Genocide Convention under Article 2, and it's Article 2C, which is the underlying act that we're speaking about today, because it relates to the right to health, which is deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. Now, this is also the definition that we see in the Genocide Convention is also replicated in the statute of the ICC when it defines the crime of genocide. Now, in the ICC Elements of Crimes document, there is a little bit of an explanation as to what conditions of life means. And it says, including but not limited to deliberate deprivation of resources indispensable for survival, such as food or medical services, or systematic expulsion from homes. Now, we've heard about this quite a lot, but I'll just mention, of course, the fact that we have a complete blockade of Gaza. We have deprivation of water, food, medicine, electricity, and fuel. So when you look at this, this may constitute that specific underlying act. This is the position of the ICJ, as in our organization, and it's also the position of South Africa that they put forward in their submissions. So really a large part of the South African case does rest on Article 2C, the conditions of life issue. When you look at the legal discourse on genocide, however, what I mean is jurisprudence and also academic discussion, a lot of the discussion is focused on the mental element because it's the most difficult to prove, but there's no real consensus as to the specific conduct that would constitute genocide as it relates to the conditions of life clause. But if you look at the drafting history of the Genocide Convention, the denial of healthcare was a persistent and consistent concern among the delegates during the negotiations and the debate. So really there was an understanding that Article 2C encompassed the right to health protection, but it's gone unrecognized. But really, we can draw on human rights law. So we can look at the development of the normative development of the right to health under international human rights law. And this can inform the proper scope and application of Article 2C. So when the court tries to define what the conditions of life means, it can also draw on the right to health. And so really, initially, the draft actually included like an itemization, if you like, of what the conditions of life would be. For example, lack of proper housing, clothing, food hygiene, and so on. But in the end, there was a decision to keep the wording as we see it now, to make sure that a broad array of conduct could fall under the definition. So that we could capture more conduct. But really, there's a nexus, the nexus between health deprivation and violations of the right to health and genocide is assumed, and it's been consistently affirmed. And I want to mention, this is a very important point, is that actual death is not a necessary condition for an Article 2C violation. So as opposed to the first underlying act, which is killing members of the group, for Article 2C, which is an alternative underlying act, you don't need deaths to occur. In fact, really all that's required is that the conduct that we're looking at, it need only be objectively capable of bringing out the destruction of the target group. So it has to have the potential to result in the destruction in whole or in part of that protected group. And even if only a part of the protected group is subject to these destructive conditions of life, as opposed to the whole group, genocide is still possible, legally speaking. I will just quickly mention that the international criminal tribunals for Yugoslavia and Rwanda did actually discuss what Article 2C means, and systematic forced displacement was also mentioned, that could constitute violating conduct. So alongside of the other conduct that I've already mentioned, and reducing essential medical services below a minimum requirement, and so on. So really, it seems clear in terms of what the conduct could be, but the level of severity is not defined in the jurisprudence. In the current case, if we're just focusing on what has been occurring since October 7 in this domain, I think the severity level is extremely high. And I don't think it's going to be an issue, whether it's for the International Court of Justice or the International Criminal Court, if we ever see a genocide investigation and charges there. But in terms of what the other participants were talking about, which I think is a very good point about the historical and systemic denial of healthcare to the Palestinians, the severity question would have to be defined, would have to come into play. The other thing that I wanted to mention was that the issue of prevention of genocide and the obligations of other states. Now, you've probably seen in the media that following the ICJ decision, there were questions raised about, notwithstanding Israel's obligations to fulfill the 6 orders, what about other states? What do they need to do now as a result of the orders? And other states, the aspects of the Genocide Convention that can engage other states are, of course, the obligation to prevent genocide. And of course, there's also a separate violation that can arise, which is complicity in genocide, but I'll focus on prevention. Now, when we look at the relationship between the obligation to prevent and what would be an Article 2C violation, there's some ambiguity. But in my view, having regard to the fact that the court ordered Israel to allow humanitarian assistance, to allow immediate and effective humanitarian assistance, in connection with South Africa's claim that this underlying act of genocide is being committed, then we could say that in terms of third states, they would, at a minimum, have the obligation to act in a way that ensures that Israel can fulfill this aspect. So that would imply in turn that states should ensure and at least not obstruct the provision of humanitarian aid. And now I'm mentioning, and I think this is probably on your mind, the defunding of UNRWA by several states. Now, just simply withdrawing funding for UNRWA is not going to automatically mean that states are violating their obligation to prevent genocide. It's going to be case specific and depend on the facts. But if by withdrawing the funding, UNRWA is, completely rendered completely ineffective, and then those states then don't compensate for, let's say, the way in which they've obstructed the operations of UNRWA, then there could be a case to say that they are actually not fulfilling the duty to prevent, because there is a connection that the court has drawn between the provision or the lack thereof of humanitarian aid and genocide. So and I am just focusing, of course, on October 7 on, but really other states have, I just wanted to make the point that other states do have an obligation as well in the realm of ensuring respect for the right to health and all of that encompasses in this current context through their own conduct and their own acts and omissions. So basically, just to say that also that all the evidence that would constitute an allegation that Israel has violated the right to health, whether it's from October 7 or even before in historical terms, could be used to support a charge, if you like, of deliberately inflicting on the group conditions of life, calculated to bring about its destruction in whole or in part. And as it has already been mentioned, it's both the Genocide Convention and the Apartheid Convention mention this deliberate imposition of living conditions. And the Rome Statute makes a distinction, though, between the crimes, because it defines genocide in Article 6, and it's separate from the definition of crimes against humanity in Article 7, and the crime of apartheid is listed as one of the underlying acts of crimes against humanity when committed as part of a widespread and systematic attack, of course. But really the main distinction, is, let's say, between the crimes of apartheid and genocide is the question of intent. So, of course, when it comes to genocide, we're talking about the state of mind in which the perpetrator intends to destroy, in whole or in part, a national, ethnic, or racial or religious group. So it's the destruction of the group. And on the other hand, of course, apartheid is the intention to maintain a regime of systematic oppression and domination. But in terms of the conduct that would be drawn on, or the evidence that would be drawn upon to level a charge of apartheid as a crime against humanity and an underlying act of genocide would be the same in terms of the acts, let's say. But then the distinction would be made in relation to the question of intent. So I hope that clarifies the legal framework and the way in which the norms, let's say, in the prohibitions in genocide and apartheid relate to the right to health, and how evidence that would be used in one, to prove violations of the right to health can be used to prove the cases for genocide and apartheid. But I noticed the time, and I'm happy to take questions if anything has not been covered already. Thank you.
Thank you. Thank you so much, Catherine. That was incredibly helpful. I appreciated the, again, drawing on the history of the development of the Genocide Convention and the importance of the right to health in shaping that conversation. Of course, there was already a question in the chat about the role of third states. So I'm glad that you've touched on that particular issue, which we can certainly expand upon, because we have just under 30 minutes for questions and answers. Then there are a flood of questions that have already come in, and I would encourage those who would like to ask some questions to please please do so in the chat. I'm going to try and group some of these questions and then pose them to our wonderful panel of speakers. Rania, perhaps I could start with you. There's a question about whether Israel's refusal to scale back its offensive campaign, despite all of these allegations from the ICJ, whether this sets some sort of new precedent for warfare moving forward. And the question is, can we expect an increase in obvious international humanitarian law violations with impunity among an increasing number of countries around the world? It's sort of the broader question around respect for international humanitarian law, international human rights law, and to what extent does Israel's behavior in this current context exemplify some of these questions? And perhaps to connect the dots between that and a second question, which was posed around whether we can trust Israel, is the question, to keep to a permanent ceasefire. I think it's the broader question again of whether or not Israel will uphold its obligations as a member state of the United Nations under these different conventions. So if you could speak to that, I'd appreciate it.
Of course, thanks so much. I think the question really reminds us that Palestine really remains this litmus test for the enforcement of international law, whether it's international humanitarian law or human rights law, or more generally. But of course, it's very ominous for these violations and mass atrocities to continue without any form of accountability, which is why I think it's also very significant that South Africa has brought this case forward at the ICJ. But we do need to see other forms of accountability to really ensure respect for the rules-based international order, if we can even still talk about it in that way. And I would agree with Dr. T regarding the disappointment and also being disillusioned by this international system that claims these norms and rules, but doesn't actually enforce them. So certainly this has dangerous implications for other countries, not just for the case of Palestine, and for all peoples under occupation and oppression, without a doubt. As to whether the question regarding the ceasefire has been discussed a lot in the past few weeks, with reference also to the wording of the provisional measures of the court. And just to emphasize again, we know there's been a lot of disappointment that the word ceasefire was not mentioned, but the actual implementation of the provisions, which is compliance with the Genocide Convention, and ensuring that there's access to humanitarian aid and assistance, all of this requires the immediate ceasefire. And clearly Israel is in breach of those binding provisional measures that the court has ordered. And that really requires, as Catherine was saying there at the end, that other states comply with their own duties to prevent genocide and to enforce the norms that are being so blatantly violated in this context. And that would require really to enforce effective measures and sanctions, which is what many grassroots movements are demanding of their governments in the past few months and weeks.
Incredibly helpful. Thank you so much for that, Rania. The next question I have is for Dr. T. There's a question in the chat, and I want to read this out because I think it's a reflection of how we all feel about you. It says there's a quote that the true measure of our character is how we treat the poor, the disfavored, the accused, the incarcerated, and the condemned. And the person says, I think there's nowhere more applicable here. The true measure of our character is how we treat the Palestinian people. And they go on to say that Dr. Mofokeng is one of the few to speak truth to power in this context. But I imagine, Dr. T, that this has come at a huge cost to you personally. And I'm curious, what it must be like being inside or sort of part of the system of the UN on the one hand, as an independent expert, speaking truth to power, as the question suggests. And at the same time, I imagine having to deal with the influx of critiques and comments that are being made, and curious how you continue to do so in the face of the opposition that you are dealing with.
Yeah, I think for me, it's the reality that firstly, I survived apartheid, so that's one thing. And so there is that insatiable hope that no matter what happens, I think, and especially because that is my core memory, right? Being a child, growing up in those circumstances, I'm insatiably committed to justice, and I think for me, that's really what keeps me going. There isn't a logical explanation to it, to be honest. It's been tough, mentally. But I think no matter how tired I feel, no matter how mentally stretched I feel, can you imagine being in Gaza right now? And I think that is the reality of what keeps me going, is that I can opt out. I can have water when I'm thirsty. There are literally thousands and millions of people who are being starved to death, right? And I actually presented a report to the General Assembly in October, just this October, when this acute aggression of the 7th happened. And in that report, I speak about how food is used as a weapon, and how food and starvation are part of the agenda of violence, structural violence. And so, it just tells you how these issues have been with us. But this moment makes it very visceral. You can't ignore it. You can't shut out from it. And if you can, I'm really happy that you can, but for many of us, we cannot. And that's what it is. I don't have a choice. I wish I could opt out, but there is no choice but to fight. And I am in this moment now, and I do what I can with what I have, and that's my commitment, to the tenure of being the Special Rapporteur on the Right to Health. One who did, right, bring the anti-coloniality, anti-racist frameworks to the space in a way that seemed odd for many people. And now it's quite obvious. And that's why I keep talking about colonialism and imperialism themselves as violence, and occupation itself as violence. And so how we analyze the response, how we analyze the resistance to occupation and colonialism and imperialism has to understand that those very structures are themselves already violent. And so if we understand that, we can then contextualize and perhaps imagine a different future and a solution for all of the wars and all of the conflicts around the world.
Excellent response. Thank you, Dr. T. And I recall very specifically when you started your mandate, drawing on the work of Black radical feminists like bell hooks, Walter Mignolo's decolonial theory, intersectional feminism, Kimberly Crenshaw, in shaping how you were thinking about the right to health. And I think that's absolutely true today if we think about the evolution of the right to health and how your mandate has helped to push that framework to recognizing the intersections between these different dimensions and the realization of the right to health. So thank you for that. A question that I want to pose for Tim, and it's a question really centered around Israel's right to self-defense. The question is very critical of Hamas's attacks on October 7th and suggests that Hamas should in fact take responsibility for what's unfolding at the moment. And so the question is essentially, does Israel not have a right to self-defense, and would calling for a ceasefire not limit their legal right under international human rights law to defend themselves? Tim, I was wondering whether you'd be able to take that question, and then I will turn to Catherine to perhaps add to that, as well as another question that's directed to you, Catherine. So Tim, over to you.
Yeah, so thanks, Q. I mean, I think that there's people better placed, and I think Catherine will add to the answer. But the first thing I'd say is that it's just a classic continuation of whataboutism, which is really a political tactic of the Israeli government and many other governments around the world. From a legal perspective, focusing on what another party is doing is simply not a defense to what you are doing. Secondly, in terms of international law, and it's quite clear from the International Court of Justice's judgment that there is no way of excusing genocide, right? Meaning that even if it is that it is accepted that Israel has a right to self-defense in terms of international law, and that some kind of reaction in self-defense would have been justified, that reaction cannot amount to genocide. And so that really, for the International Court of Justice case, is the reason why it's not so relevant whether there is a right to self-defense that Israel is enjoying. But the International Commission of Jurists, we've also put out several statements, and it's really what many people have been saying, is that what Israel's responses have been over many years, and not just in this instance, are forms of collective punishment for the actions of entities or individuals that take their resistance to a level that some people would condemn, and that many people will condemn, and that almost all states have condemned, including South Africa. So whether or not Hamas is responsible for the killing of people, and they have been responsible for the killing of people, including on the October the 7th, is not relevant directly to evaluating the questions that are in front of the courts. It simply is just that simple. And the last thing that I'll mention is that it would seem to me that on a basic understanding of self-defense, if Israel was defending against Hamas, many of the actions that they've taken that we are talking about, both since October 7 and before that, in relation to deprivation of access to healthcare services, electricity, etc., would not be effective ways of really actually defending themselves against Hamas.
Thank you for that, Tim. And so perhaps Catherine, if you want to build on that response, but also there's a specific question for you that I want to ask, which is, would Israel be able to avoid a conviction for genocide by arguing that the destruction of health facilities was not motivated by intent to destroy in whole or in part the Palestinian people, but rather to destroy Hamas terrorists and their resources lodged within what they claim, these health centers or in hospitals?
Sure. Thank you for that. I will just quickly add to what Tim said on the question of self-defense and the ceasefire. So it's not actually surprising to many people who observed the case and who followed the case that the court actually stopped short of ordering a ceasefire, because ordering Israel to agree to a ceasefire would have prevented Israel from engaging in some type of defensive military action. So let's put the question of self-defense to one side, and I think the court was wise not to be drawn into that. But really, Israel does have a right to combat Hamas per se, and then I'm not talking about a right to self-defense in terms of the Charter of the UN, but surely some type of defensive military action is allowed as long as it complies with international law, and specifically international humanitarian law. And this is why because the court's concerned with the question of genocide, which is very specific, and there's the question of intent, which I'll get to for the next question, you can have, theoretically, combat or a military operation that is not genocidal, obviously, because genocide is so specific. So really all it was saying was, please do not commit acts of genocide, and make sure that your army, your military doesn't commit such acts as well. And of course, those acts need to have the intent to amount to genocide per se. Of course, they can amount to other crimes under international law. So as long as Israel does not intend to commit acts that violate the Genocide Convention, they're allowed to conduct military operations in accordance with international humanitarian law. So really, this is why the court did not actually order a ceasefire. And I want to point out that in the case of Myanmar, which their court also didn't order such a ceasefire. Now, in relation to the second question, it's a very good question. Now, of course, I touched on the question of intent before, and I mentioned that a lot of the scholarship and discussion about legally speaking about genocide focuses on the mental element. So genocidal intent, it's a specific intent. It's a specific intent to destroy a group in whole or in part. It's very challenging to establish this in terms of the proof that is required. And of course, if you're speaking about a criminal case, that's a beyond reasonable doubt standard on the specific intent. So you can only imagine how difficult it's going to be if genocide or charge of genocide actually comes before the ICC in relation to the Palestine question. So really, what South Africa claimed was they claimed in their submission that there was intent. And the evidence of that for South Africa was the statements made by Israeli state representatives, including the Prime Minister and the President, and the conduct of the military operation. It wasn't just simply the statements made by those who have some type of command and control over those who are perpetrating the genocidal acts, but if you look holistically at the way in which Israel is conducting the operation, they're failing to ensure food, water, and medicine and humanitarian assistance for a besieged strip, and the sustained bombardment. So, and the sustained bombardment that has resulted in a huge mass displacement within the Gaza Strip. So I think something like 90% of the Gaza Strip is displaced. And then they're displaced into smaller and smaller areas, and then they continue to be attacked, killed, and harmed. Now, it's true that a specific incident could take place where it's a targeted operation, and a hospital, for example, is targeted because Hamas is actually using it for military purposes. But international humanitarian law is very specific. So, for example, if a hospital, which is supposed to be a civilian object, is actually being used as a military object, nonetheless, warnings must be given to civilians to leave They have to be evacuated from the hospital, and then it can be, let's say, targeted in a way that minimizes the effect on civilians. So we can look at the way in which Israel is conducting the operation to argue, at least, I mean, we're not those who are deciding, we're not judges, but you could at least argue based on the evidence that we've seen that they're not complying with IHL in the way that they are targeting Hamas. And that also the effect and the way in which they're conducting it, which is without precision, even though we know they have the capability of being precise, is also suggesting that it's not simply a matter of trying to eliminate Hamas. So this is a great question, because this is exactly what judges would be deliberating over. They would be poring over all of the evidence and trying to understand exactly what can be inferred about the intent of in terms of those who are conducting the operation. So it's an open question, and it's a very difficult element to establish the question of genocidal intent.
Thank you, Catherine. But I thought you did a fantastic job of trying to set out and articulate what the law offers in the context of the uncertainty that we recognize in deliberating on these issues. There's time for one final round of questions, and so I'm going to draw from the long list that I have. And Rania, perhaps I can go back to you. Like Dr. T, you also invoked ideas such as imperialism, colonialism, settler colonialism, and so on. And one of the questions I have is, what do you think is the most accurate term to describe what's unfolding, and why would you use that term to think through and talk about and describe the conflict as it's currently unfolding?
Thanks so much for that. Yeah. So I talked about settler colonialism, which is also the framework that we used in the Al-Haq report that I discussed. So this is a report that was published in late 2022 by Al-Haq, titled Israeli Apartheid, Tool of Zionist Settler Colonialism. And I mean, it includes a longer explanation of the use of this framework. But briefly, settler colonialism, as I was saying earlier, is premised on the elimination of the natives. So we talk about this eliminatory logic that is deployed against Palestinians. We can see that in the most crude form today. So settler colonialism understands that logic as both the physical destruction of the group, and that's why it's been understood as linked to genocide, but it's also a series of articulations of the law in the way that the apartheid system is set up, that prevents Palestinians from exercising fundamental rights and freedoms, and in particular, the right to self-determination, the right to return to their homes, and so on. So we're using this framework, and I've used that in my own work, as well as previously in my advocacy work when I was working for Al-Haq. And it draws also on the obligations that states have, as some of the speakers also mentioned. So states have an obligation to prevent genocide, certainly, but also to end serious breaches of international law, which include apartheid, and colonialism is also considered a prohibited regime, and so it triggers the responsibility of states. And really, this is why it's useful to use these frameworks, both analytically, but also because it triggers state responsibility and the responsibility also of other entities, such as businesses that are complicit in Israel's apartheid regime. And of course, it raises individual criminal responsibility regarding apartheid, which we argue is a tool and a form of settler colonialism. So yeah, I hope that explains a bit the use of these frameworks. And they have, as Dr. T was also mentioning, been used in relation to public health literature and also in the context of anti-racism, which is very important. And we can see the value of that today in addressing those root causes and ending the injustices that Palestinians have endured for decades.
Excellent. Thank you so much, Rania. I want to turn to, there are a couple of questions about the funders and political supporters of Israel's actions, including the United States, Canada, and a number of European countries, Germany included. And the question, and this is for you, Dr. T, to what extent do you believe that these countries outside of Israel can be held accountable for failing to uphold international law?
I think they can be held accountable, which is why South Africa's case was important, right? Because that process happened also parallel to other General Assembly processes and Security Council processes. So we shouldn't look at them in isolation. All of them are important in the building blocks to get justice ultimately. And one of the responsibilities and obligations of member states is prevention of genocide. And those who are assisting Israel in this are failing in the prevention obligation. And also just to remind people around the issue of self-defense, as an occupying power, you can't claim self-defense because in 1990, and this was in the context of both South Africa and Palestine, the UN General Assembly spoke very clearly about the fact that it had condemned at the time the apartheid South Africa's establishment and use of armed groups, right, to destabilize the legitimate armed struggle for freedom. And they actually went as far as saying that the UN reaffirms the legitimacy of the struggle of people for independence, for territorial integrity, for national unity, and liberation from colonial domination, apartheid, and foreign occupation by all means, including armed struggle. So you can't be illegally occupying someone's land, and when they resist, you claim self-defense. They both can't be true, right? And it's the same language that they use when settlers in the occupied Palestinian territory themselves become de facto enforcers of law and violence. And when it suits them, they call themselves civilians. But when it suits them, they put on armors and they pretend and they act like they are police, right? So even this idea that Palestinian people must constantly be policed and brutalized and dehumanized, even in the language. You see the epistemicide that has carried on right now in terms of the culture, the heritage, academia, the destruction of the healthcare infrastructure. That goes across all of the rights, economic, social, cultural, political, civil, and that is genocidal in nature. We didn't need the 7th of October and the escalating violence thereafter to prove that there was a genocide. There was already a genocide before the 7th of October. What has happened now is that you've got an international court, which is an important arm of the UN's work, affirming that, in fact, there is cause for concern. And that enables people in other jurisdictions to therefore hold their own governments accountable, their own leaders in their own countries as members of the United Nations accountable for their participation. Look, in closing, KM, there were allegations, right? Allegations that UNRWA staff may have been involved somehow with Hamas. Allegations. Based on those allegations, you have many rich northern countries, former colonial powers themselves, who immediately withdrew funding to UNRWA. So they understand the concept of divesting, they understand the concept of boycotting, they understand the concept of stifling and starving of resources, right, based on allegations. On the one hand. On the other hand, you have the ICJ saying there is probable evidence and a huge cause for concern that a genocide is happening in Israel. And then you have the United States sending more billions of dollars and more nuclear weapons. The hypocrisy is there for everybody to see. Those are not the people, I'm sorry, that can claim self-defense. I don't know a victim that can decide to starve an entire nation of people. It does just not exist. It does not exist. Absolutely.
Absolutely. And I feel like that point is something that must be emphasized consistently in the narrative that's being conveyed around the question of self-defense. So appreciate you touching on those issues in a very clear, concise way. Unfortunately, we have come, as always, to the end of this wonderful webinar, and there's only 1 minute left, which is really just an opportunity for me to thank you all for your participation in this incredibly powerful webinar. I want to thank particularly our host, the FXB Center for Health and Human Rights, for creating this space, which I know has become a very difficult spaces for us to even host these conversations. So really want to applaud the FXB Center for creating this space. There was a question about whether or not this will be available, and the recording of this conversation is taking place, so we will make sure to share that with all those who have registered for the event, as well as on the FXB website. Again, my deep appreciation and thanks to all of you for your participation, for your excellent questions, and look forward to an ongoing conversation around this critically important issue. Thank you so much. Bye-bye.